recorded a video and it ended up being really, really long. I started talking about Harold Godwinson and then it ended up with all the modern problems. Look, I've just been staring at that mace on that table and I've just kind of like had a bit of a revelation. I know that some of the speakers in this video are really into their Magna Carta and into their Constitution and Bill of Rights. And they've started talking about that in councils now, like here now, which is good in this video. I've read a book the other day, and not all of it, but I picked some important parts out of it. And it basically it's giving all the council functions, but at a very early phase and stage of them, right? Around the 1600s, okay? Late 1600s. But why is that important? Because the structure of the council as compared to government, right? There are some important processes, right? And in this video, one of the gentlemen just stood up and he said, "Oh, I teach Magna Carta, I teach students and so forth." And he was like, saying that he teaches it, but he was like opposed to the guy who's speaking. Now, the thing is, what we need to get clear is that there are some things in those acts which cannot be contravened and which have to be done, right? Must be done and cannot be like legislated against. Now, they might say, "Oh, well, certain statute laws have changed this or that." Whenever something is still in effect and still in law, you have to abide by that rule. It's like a computer program, right? And all of the subsequent laws have to provide for it or be compatible. So there's compatibility and there's provision, and it can't contravene it or omit it, right? Now, there's an argument where, for example, like with guns, they might say, "Well, you've got the right to bear arms, we can't stop you, but we're going to make you have a license. So if you don't have a license, you're going to be fined." So you say, "Well, you can have it, we're not stopping you from having it, but you've got to have a license," right? That's an act of law, but that act of law has got to allow you to have it somehow, right? Now, if you don't have a license, will you get fined or locked up or put in prison? This is the thing. And can you have a jury trial? And can they say, "Well, we don't think they're guilty," right? Even if we don't apply law. And it comes down to also understanding, in the Bill of Rights, you've got the right to bear arms as by law. Now, is that as by made by law then? You can have them and they can't stop you from having them. If they can't stop you from having them, then they can't take them off you. So that means that if you don't have a license, if it says that they've got to let you have something, right? That's different from saying that they can't stop you from having something. If they can't stop you from having something, then they can't take it off you. So that means that they can't fine you and put you in prison for having it, because you can't not have it, right? And the whole point of bare arms is bare minimum. It means when you're stripped down to nothing, you've still got your fingernails, right? That's why it's a bear with claws, which are part of its skeleton, right? Bare arms, right? Because it means the right to raise a hand, whether it's tooth or claw or sword, and use that for the means of defense, right? Whether you have a sword or you're stripped down to your bare fingernails doesn't matter. That's why it's bare arms, because you might be bare, you might not have any clothes on you, you might have nothing, right? But you've still got two arms. You can't take your arms off you unless they cut you off. So they're saying that anything, whether it is your hand or a hammer for the use of defense, they can't stop you from having it. But also, they can't stop you from, walking around without any arms unless you're disabled, right? So there are these things that need arguing, and sometimes they haven't really properly been argued, or we've been fobbed off or scammed, and a lot of those need to be gone back to and argued out in court if they challenge it. But what you actually find out is that, okay, modern legislation completely and totally bans, automatic weapons, right? Automatic weapons are completely and totally illegal. The right to bear arms doesn't say which arms you can and can't have, right? Well, now that might be saying when it's coming to knives, but everyone's got knives in their kitchen, so when you distinguish what is the use for them, well, the use of knives for cooking is for food, right? That's a usage. Now, the law says that for defence, so that's a usage thing, not what type it is. So, suitable for their means. They can't stop you from doing it. Now, I don't really want to use the bear arms example, but when we get back into the council and the structure of the council, right, we get onto all these things like petitions and juries and appeals and committees. And those things, there are certain things they can't stop you from doing or having, like the right to petition the king, right, or the parliament, and the right for judgment of your peers, right? When you have councillors who are elected, but they're a lot of them are party affiliated, right? And when you've got a jury at a higher court, it's a random jury, not elected councillors or even jurats or whatever the equivalent of. What I think we need to do, what I want to do is get little drawings with like little, simple, like an oval shape with writing inside it saying, like this is a councillor or that's another councillor and this is the council body. Little very simple basic spider diagrams, right, of the different structures of councils all the way from the start in order or in order of significant change. And check whether they all are first lawful to what the Constitution says they must provide, and secondly, if they currently are offering everything that they're meant to have to offer, which must be possible. And actually what the council even is, because when people look at a council now, they don't even really know what it is. It's ended up being a coalition enterprise between two political parties with minimal input from the people, right? But yet they use judicial power and authority and make orders, right? When they've got a selflessness policy, which is impossible in law if their elected members are also serving political parties. It's a coalition of parties. Now, I really just wanted to start opening my mouth and talking about that mace, right? That mace is really, really, really important, right? Now, the local council, okay, when I was reading the Scottish Government book, right, you've got it listed every single different area of Scotland. There was a list of all the different areas, every area by name. Right, and it was all on one page, right, A to Z. And each one of those areas had elected, right, 6 councillors, right? And then you've got 3 magistrates. And if it's a town or city, it's slightly different because you have a mayor, right? And then you've got a sheriff. Now, this is the thing, right? That's what you've got. That was it, right? Now, then you have your assizes and your quarter sessions, which are the King's Court, who comes round for more serious matters or appeal, right? Or appeal. And now the assizes are the Crown Court. And we don't have the court sessions anymore because, Crown Courts are just running all the time. But it's meant to be the circuit judges, right? They're meant to be the King's judges. Now, I think what the local councils are trying to make out the local councils, right, are trying to make out that because they've got that mace in that chamber, right, that it's sort of an extension of Parliament, right? Almost like Parliament, but in the local government area for all local matters. And that council deals with all those local matters, not Parliament. But Parliament actually does deal with law that affects them all and the whole country and how they run, right? It is hierarchical, just like the assizes and the quarter sessions are where you appeal up to, right? Now, in that model, I'm quite certain, right, in the local areas for the Scottish Government, I'm quite certain that from the looks of it, from what I've read, and I need to read the rest of it to fill myself in on the details, but at the moment, I'm sure that all matters were put before that court. All different matters, whether it's civil request, criminal, or disputes between parties, unless it's serious. And then the King's Courts hear it when they come round, and you have a random jury. So the council is a court, right? You can see that with the Sam Sterling in the William Penn case, when they've got the aldermen. Well, there's 4 or 5 aldermen and the recorder, that makes 6. And then there's Sam Sterling, the mayor, right? It's a criminal case, but they've got a jury in on the side, right? But that's in the City of London. But it's a criminal case and the mayor's sitting it, so that's really important. And your alderman, right? Now, I think that the cabinet, the 3 justices, I think when the sheriff brings in the persons who broke the law, I think that they're in front of the magistrates. I don't know if they have all the councillors there, but in the Sam Sterling case, they do have the councillors there, right? But you're saying, well, if they're jurats, if they're like literally kind of like a jury but permanently elected, right, like your councillors, why is there a jury sat at the side of it? Well, that's actually in the Old Bailey, which is a higher court, right? And it's also in the city. It's actually the criminal court, which is like the assizes. So you've got a random jury in there, right? And all the councillors who would be there without a jury. Now, the thing is, what I've just thought now is, so you didn't have, like, in a town now, in a normal town, right? You've got a county court, which you never had that before they abolished the assizes and the quarter sessions, right? Because with the assizes split into county and criminal, right? Your Crown Court. It's just it's the King's justices going on a circuit, and they have criminal and civil business, right? Doesn't matter what it is, they've got business to do, as councils like to say. The King's justices on a circuit doing King's business, right? You got different types of cases. Now, this is really important. The council, now you've got a magistrates court and you've got a county court in a town and you've got the local council. You didn't have that. You only had one. You had the elected permanent jurats or aldermen or councilmen with the magistrates, right? That's what you had for each area. And you had all different manner of cases, just like the assizes had all manner of cases, but at a higher level for more serious cases, right? Serious criminal cases and for appeals. Now the thing is, right, that this is the thing. It says that if you appealed, so you've only got one body, right? You don't have this, a Crown Court, a Magistrates Court, and the Council Chamber, right? With the King's Justices coming around for very serious matters, every 2 months, right? You just have one, right? And then the King's Justices coming round. You've got the Divisional 100 Court. Now, what they've done is they've like, from that one body now, right? From that one body, it's like had babies. It's multiplied, right? It's almost like getting a stamp, a template, and you go stamp, 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 right? And miraculously, it's multiplied into 3 courts, right? It's multiplied into a county court, a magistrate's court, and the council chamber, right? Now, the interesting thing about the magistrate's court is you have 3 justices, right? Or a district judge. Three justices or a district judge, right? But really, it is not. It is meant to be, or supposed to be, no other than the council. Still the council chamber. But what they've got is 3 magistrates who are appointed to criminal cases, right? The 3 magistrates are appointed to hear criminal cases because the council is busy doing its civil requests, right? Civil matters. And plaintiffs who have a dispute with each other, John Simpkins versus, Sally Bailey or whatever, it owes them £10, is in the county court, right? Which you can have 3 magistrates or a district judge. They usually have the district judges in the magistrates court, goes to the county court, right? So it's for convenience and, volume of business. Volume of business. What they've done now is they've separated and specialised. But get this, it said that if you have a decision in the council chamber, right, and they vote on it, which is your councillors or aldermen, whatever, or jurats, permanent ones, not the random jury that's chosen at random from the public when you have the assizes come round, right? The permanent councillors stroke jurats who vote and make decisions, right, and usually dealt with everything in that area, it says that you can appeal to a committee of 3, right? Now, isn't it funny that you have 3 magistrates? You have 3 magistrates in a criminal court or in a county court. Isn't that interesting? It's almost like a committee of 3. It's like a committee of 3. It's almost like, if you got 3 of these councillors from here, well, they have the cabinet, right, for those matters. It's almost like if 3 of them went off, and they've got a separate court to hear different matters, right, or to even appeal to it. Now, I have heard some of these councillors say that one councillor can make a decision on this or that, or certain things. One councillor can make a decision on it, right? He himself makes a decision on this or that. That's kind of like a committee. It's like having a committee, isn't it? But he can do it by himself, apparently. He can decide on matters for this or matters for that. He's got the power for the final decision, right? But that's not 3 people, though, is it? How can he do it by himself, just one lone councillor make decisions without a committee of 3? Because he's not a district judge, is he? So that's interesting. So it's definitely absolutely clear now that this chamber that we've got here would be hearing crimes, because obviously you've got a lot less people in the town, a lot lower population, crimes and civil disputes and business for the council for making decisions. But they've split it off because the councillors were justices of the peace. But what the council are trying to say though is that there's no appeal once they've made a decision. Well, you can appeal criminal matters, you can appeal civil matters. So it's absolute tosh that you can't appeal the council decision, right? It says that if you want to appeal it, it goes to a committee of 3, which is kind of like judges or magistrates. I'm quite surprised that that's not the county court, that you can actually appeal it to the county court from the council and not a judicial review, actually an appeal of the decision, or a committee of 3 of the members of the council, which that's not going to be really, really happy to the council, is it? Because if they've got a big planning consent for the whole redevelopment of town and they all voted on it and then they made the decision, the whole lot of them, then if it goes to 3, a committee of 3, who's going to be in the committee? And can they override the whole council? Right? That's the thing. It does say that after that committee is decided, then there is no further avenue of appeal. But it does say if they haven't followed the rules or they haven't followed the law, it goes to a judicial review, which is, guess what? The court. The High Court. Right? It's meant to be, the judicial review was supposed to have a jury like the assizes, because they either didn't apply the law or didn't do something right. For example, like, if they couldn't have done it in the first place, or if they didn't actually apply law or something. So, but as for the actual decision itself, it definitely says absolutely that you can petition for the Lord Advocate to have the matter with a jury instead of that local authority, which is the right to petition the King's Justices. The assizes are the King's Justices on the circuit, right? So, and everyone has the right to petition the House of Commons and Parliament, which is making the law that this council runs on. Now, if they're trying to make out that there's no avenue of appeal after that council's made a decision, I think that is wrong, because everyone has a right to petition the King and you cannot stop that, right? And also, when you bring the petitions into the council are meant to have a slot for hearing petitions. And also, if you get so many, this is modern law now. In modern law, it says that if you get equal to 5% of the electorate, right, you're entitled to, and that means that not just you're entitled to it, but really you should have it, or they've got to give you it, right? If you produce a petition that has 5% equal to the electorate, and I don't see why that can't be a ward. It doesn't actually say whether it's the electorate of the entire county or whether it can be a ward election if you want to get an election in a ward. A petition in a ward. It says that you can have a local referendum, which means the people decide, and that is effectively like if you go to the assizes and have a random jury, it's only going to be a small amount of people. You're actually asking everyone. The Secretary of State, though, is the one who grants it. Now, this is in modern law. That means that it means that the cabinet of the council, the 3 equivalent of the magistrates in the council chamber, not with all the rest of the councillors voting, right? They even cannot approve the referendum. They don't have the power to approve a referendum of local electors to decide, and not the council decide. So that means that Parliament of England, the Parliament of England and the Secretary of State, who you can petition through the Petitions Committee in Parliament, right? That means that Parliament is Parliament is authorising the local referendum. So that's with the authority of Parliament, not that Mace in that council. The one at Parliament. And that it means that when you're collecting the signatures from the local people, say for Colchester, for a referendum where they decide, not the councillors in the chamber, where the people decide, it means that if the Secretary of State have got to approve it, then it's not. This isn't the Local Government Act. The Local Government Act, right? This is a prescribed procedure which no one wants to. I wish more people got extremely keen and interested on it, because it doesn't even say that it has to be the entire whole county. No one's saying, it doesn't say that you can't have a ward referendum. No one says that you don't need 5% of a ward, right? If it's a building consent or something. If Parliament, and I've said this repeatedly, right? If you're collecting signatures in Colchester, but the council, the entire assembled council, cannot approve that referendum under the Secretary of State, you're not petitioning the council, are you? You're not petitioning the council for it, are you really? Because they can't approve it. This is modern law. So are you petitioning for it? Who are you petitioning for the referendum? Who are you petitioning for the referendum under the Local Government Act in modern law? If you're collecting petition signatures from a council, but they can't approve it, who are you petitioning? You're not petitioning the council, are you? You're petitioning the Secretary of State for transport or whatever, which is what? The Parliament. Oh, so we can't petition Parliament for the people deciding for a referendum. Oh, right. So it isn't just the council's decision, is it? Right? Maybe if they've already made a decision, but we're getting gypped off about whether they should be the ones deciding on it or not. And actually, even if they do, you are meant to actually be able to have it go to a committee. And obviously, you can go to the courts as well, which is the King's Circuit Courts, if they haven't followed the rules properly or done it properly, which is basically you're actually taking them to court, a higher court. So, and also the Lord Advocate is meant to be, if you're challenging that the council have done something wrong, right? The Lord Advocate is meant to do it, which means that really we're not supposed to. If you've got evidence of the council doing something wrong, breaking the law, then we're not going to pay for it. That's the Attorney General. That's contempt of court. Attorney General is bringing cases against Tommy Robinson now for contempt of court. Citizens in contempt of court. When you accuse the council of breaking the law, and you've got enough evidence, like, you've got enough evidence to go to the police and get the CPS to prosecute someone, right? The Attorney General or the Lord Advocate is meant to prosecute the council if you've got substantial evidence, because the council broke the law, the council that we pay for. Why would we pay for a private lawyer when our own council that we've paid for is breaking the law, right? It's public services, it's duty, right? If Sally, if someone brings planning permission in to do something, right, that is another party, and we're opposing them, right, and that other person does something wrong, then you should have to pay for it yourself, right? Because you are opposing that person, or this is when those other committees come in. But the thing with the council development projects is that they're meant to be conjured up by the council and by the strategic planning and by. Although this is the thing, when a council redevelops a town centre, right? Who's actually doing it? Is it actually just like Sally Simpkins going in and saying, "I want to extend my garage"? Is it really some keen architects and university professors and big developers who put some money on the table and say, "Hey, how about these plans for the town centre? Is it really another party, or is it actually the council?" Because it seems they'd be putting a lot of resources and work into it, right? Seems to be a lot of resources. Seems to be a hell of a lot of resources. The council have got all these models on the table, and they've got all these people they're inviting round, and they've got all these other processes, and then they're paying for some of the a hell of a lot of meetings over it and so forth, and they're even getting certain people to support it. Certain councillors backing it and so forth. It seems like a big, garage extension or a big change of usage case. Who's doing it? It's presented as it's our idea. We came up with it. The councillors came up with it, but they're selfless. If they're selfless, how can they come up with it, right? Oh, like the highways department came up with the idea. Well, no, the highways department are there to maintain the roads and so forth, right? And maybe the central government have got certain schemes. This is the thing. No one owns the roads, right? McDonald's can't buy the road and say, let's redevelop it. Councils maintain and build roads, right? I accept that. So, when it comes to universities and, things that the council owns, they own certain buildings like museums and so forth, then yeah, if the council own it, it's them. Now, if they break the law, right, surely if the council break the law, it's not a private independent party, is it? It's not like John Watson who wants to extend his garage. He's a private party. It's a private garage that he owns it, right? If the council own the town centre, or a significant part of it, like the streets, if someone wants to change his shop usage, it doesn't affect the street, The council are redesigning the streets, so it's owned by the council, so that's where they figure into the whole thing, right? If the council break the law, right, why should any private citizen who actually pays their wages have to pay for a lawyer to prosecute them privately? They don't. Says that if they broke the rules, like broke Magna Carta or broke the Bill of Rights or didn't apply the law properly or broke a procedure, then it's meant to be the Lord Advocate, which is like the Attorney General, right, who's supposed to do it because they're in contempt. They're in contempt of the council procedures. They're in contempt of law, right? And it's like phoning the police up saying, someone kicked me in the face. The council broke the law. But the Lord Advocate and the Attorney General aren't going to do it if they're in the same political party as them, because it might be, if it's a political party project, then you can't have the Lord Advocate who's a member of that party and saying, I'm all for this, because he's meant to act independently as a prosecutor at a high level. So, with judicial review, you should only really have to pay for it if it's a private party, not if it's like the actual council. It's meant to be the government, but you've got to have enough evidence to show that they broke the law, and what if they won't do it? Well, this is the thing, they seem to be keen to get the Attorney General when it's Tommy Robinson, who's been in contempt of court. They should be equally as keen if anyone claims the council broke the law or the rules or whatever. This is the thing in their projects, not private persons' projects, but the thing is, a lot of their projects now are interweaved and doing lots of deals and handshakes with private projects, because what they do, like a cooperative, collaborative project, you scratch my back and we'll scratch yours, we'll change the town centre streets to fit in with these business people, and we'll all do a handshake deal. But if that's corrupt, then how can any person in this country now, even this cost of living crisis, even contemplate getting the money to have to pay for any legal fees privately for that. You know, if the council are involved in when they're the ones making the decisions in it as well, and their own street regeneration and changing depends on those other ones getting passed. So it really is quite corrupt at this level now, to the extent that there's lots of deals with private businesses. The political parties really want to decide, yet they're meant to be impartial in the council. And this is, I think, where that power in the Local Government Act and in the Local Referendums and Elections Act, it designs a modern model. And there's no dispute or argument about this, because it says that you can have a local referendum. Now, this is where my argument comes in with how we're being conned in all these big projects. The councils now, to appear democratic and appear to be listening to the people and appear to be all above board and political and presentable and fair, do these public consultations. Oh, we're asking the public what they think. So they're actually funding the thing that you would have to go out of your way to collect 5% of the electorate, the signatures, to get them to do that, which effectively is a local referendum. A consultation is a referendum, because they're asking everyone, and it's the fact that they announce it and say they're doing it, and they're facilitating taking the comments, right? Which is the same as the petitions committee. All you've got to do is share it and let people know. Well, when the government announced the project, they're meant to have given sufficient notification that everyone is notified in the whole voting area. Everyone knows there's going to, as far as they're concerned, they gave sufficient notice in law that there was a redevelopment, that you can object to it, or there is a consultation, and they give notice in the newspapers, on their website, and so forth, which is the equivalent of like a referendum. They've got to tell everyone that it's on, right? Well, they're not having polling stations everywhere, because they're doing it through the local council website, which they're meant to make widely available to everyone and know where it is, not hidden behind some little clicky tab that you can't find or whatever, right? But what they're doing is they're saying now that those results of that consultation, they only have to look at them just to get a general idea. They don't have to go by it. So they're saying it doesn't carry any judicial authority. Now, that is a major political party scam. That is Labour and Conservatives really trying to cheat the people out of their judicial powers who didn't vote for those parties. Like, you know, the other third of the people who don't vote for those parties or don't vote at all, but might not want the town centre redeveloped, right? And really, in a system that is built on referendum, has a judicial authority and power of effect, it really is a con and scam that they wouldn't have to. Now, you might say, well, it's all been created in law and the consultation, blah, 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 and policy. But this is when we have to go back to Magna Carta and back to the Bill of Rights and back to the council model, right? A petition is a petition. A petition is you have collected the opinion of the public, the electors, and it's on paper, on record. Whether it's just their signature, for or against, or it's got more details of comments, which is a statement attached. You can never devalue and remove the judicial authority of a petition, because it is the you're going to the electors to actually ask them what they think and get a statement. In a court, a statement can be used, and in a council, this is what an objection is. This is what anything is, right? Even when you write it in letter and say it in writing, it always has authority for proceedings. You know, whether it's a statement or not. So, a petition's always a petition. A petition is you put the question of any matter, and members of the public who are registered voters write statements down, right? And that petition, they've got slots where they have to hear petitions in the council sessions, right? Now, that guy in this meeting just said that he made a decision about the toilets, and, Rachel said that, oh, well, I've done a petition. Well, I signed it. He said that he hadn't heard anything from anyone. Well, we submitted the petition. We signed the petition and put comments on the petition. So, and there's meant to be a slot for hearing petitions. So if they somehow haven't heard the petition, I don't know how that's possible, right? So the petition carries weight because it compels the councillor of any ward on weight of numbers. And if the petition can persuade him on argument, on statement, some persuasive reasoning, or numbers. Now, if the reasoning doesn't persuade him by weight of evidence, right, this is where that referendum thing comes in with 5%, because if you have any councillor who's responsible for any ward and he's got a selfless policy and he has to vote on anything in that chamber, if you return, right, any numbers of electors, signatures, which are more than 50% of his ward, it doesn't matter whether they've got a reasonable argument or not. You don't need one because you've done it in weight of votes. And that councillor, when he sat at that table, is compelled to act on the majority of his constituents. It doesn't even matter if there's any reason or not, just for or against, yes or no. And that is how it is. And if it's overriding his Labour Party directives, then tough. And that's really what Labour don't want. And if you go do that for each councillor, then, the people have really got control of the council. Then if they can be bothered to, in each planning application, in each matter before the council, and this is the thing. But that petition to the Secretary of State for a referendum where the people will decide, not the council, which that is in the Local Government Act. It's a modern basis. But what is that? What even is it? What is that? Well, it's petitioning Parliament. It is opting. It's opting to petition Parliament. It's opting to petition Parliament. And what Parliament does, rather than they're busy with the business of the whole country, right, even though Gareth Johnson's trying to get ULEZ debated, what the Secretary of State does, rather than allocating time in the chamber, in the Commons, to debate it when they're more bothered about sacking Boris Johnson or whatever, that's why he allocates you a local referendum. Right? So we vote on it. Actually, not the Commons chamber. Do you get it? So it says that in 1688, in those local Scottish ones, it says you can petition the King. Or get the Lord Advocate to get a jury together to decide it. Same thing. Still got it now. It says you can have it. Right? So the local council actually, you don't have to have the local council deciding on redevelopment of the town centre. You can get the Secretary of State to give everyone a local referendum, which is petitioning the King. What does he do? Well, he actually, rather than getting the assizes coming round and choosing a random jury of 12 people, so say, let everyone vote on it, right? And why wouldn't you if it was a controversial town centre redevelopment? Oh, look, they already did a consultation and did ask everyone. What a coincidence. But regardless of what the outcome of it was in the majority, they don't have to stick by it. Well, what a absolute con. Oh, don't worry, don't go to Parliament and, get a little local referendum that has some validity to do it. We'll do an invalid consultation, and won't that be cost effective? Hey, anyone want to waste some council money that could be keeping those toilets open for another 5 years on a completely pointless consultation that is invalid, that doesn't have any validation to it, that you don't have to stick to it. Let's spend council money running a consultation that we don't have to do what the results dictate. We can just ignore it, and happily know that we're not doing what the majority of people want, or what the people who cared want, right? When the same amount of money, effectively, if the Secretary of State authorises it, if someone can be bothered to collect with 5% signatures, and it says that you're only meant to have one of these every 5 year, or every year, or every 5 year referendum in a local area, but it doesn't say in the law once a year for what area. It does not say explicitly that you can that every Kirklees Council can have one a year. It just says that one referendum for what though? Well, what happens if someone's building a housing estate in an area called Bromsby Ward, and someone's building a housing estate and they want to stop that, right? Well, it doesn't actually say that you can't collect 5% of that ward and have a referendum of that ward. That means that, it might be 3,000 people who go into a polling station at one school or 3 schools near it and vote on whether they should be building a housing estate or not. Does not say you can't do that. And, in fact, it is the right of the subjects to petition the king, and all prosecutions and commitments for doing so are illegal. And it's the right of the subjects, any subject. I am the subject, I speak the subject, I am the instrument, and I play the tune. The subject, the right of the subjects, the right of the harp to be a harp and be played and make a tune. The right of the subject, the right of me, of us, to raise a subject, right? Any subject. We've got right of subject, so it could be town centre redevelopment, local planning thing. It's the right of any subject, right? Whether it's redevelopment, any subject, whether it's toilets being open or closed, any subject to petition the king, right? And and if you want to say, well, you already are doing with the council, well, that council has not been hearing that petition about those toilets being open or closed. Apparently, he didn't get any emails, even though he's been sent a petition. It is actually the Parliament. You've got a right to petition Parliament, and that's why the Secretary of State authorises a referendum, because rather than they're actually letting the people vote on it, not the ministers in Parliament, and that's like you're literally. But the alternative to that is it does actually say. Now, this is the thing. There were a lot of different council processes in the Act. There is some council process. This is the thing. The council deal with a lot of business. The council deal with planning consents. The council deal with maintaining the streets and roads, council tax. There's lots of different things that the local council deal with. Now, some of those things you could actually get, you could ask for it to be decided with the King's judges when they come around at the assizes and have a jury there on whether they should raise money for repairing the road or not, or for various things like that. And then other decisions weren't, right? And that's what we could do with getting clarified. I actually do believe now that I think now that if it's an important or serious matter, I actually think that you can decide to have it not have it decided by that local council chamber. I think you can actually have it decided in well, the thing is, it's meant to be the assizes is the Crown Court, or the quarter sessions. But the thing is, they only deal with criminal matters now. So they've put it into the county court, right? But the county court and the high court are also linked together. The normal county court is only meant to be the same level as a magistrate's court, which is the same level as a council. So what I actually think now is they've really, the council civil requests has been really split into the county court and the council chamber, although it's the same level and it was all in one. And the county court is meant to have a jury, right? But the jury were actually at that level just the councillors. So it's kind of like the county court at the normal level deals with, issues between, John and Paul or Sam and Phil or whatever with their own personal issues, private issues, common pleas, right? Which is plaintiffs, civil disputes, torts, right? But they were all out of the normal council chamber. The issues that could be put to a jury, you would have thought that that's when the council court had its assizes, which is kind of the high court doesn't come around on a circuit anymore, but you can have a high court decision in a local council court. It's funny how they do it, but it's like the assizes, but the civil side of the assizes, which it's funny how they do the local court, because you can appeal from the county court to the high court, right? But the high court they're saying that it can be held in the local area, and they only really have certain high profile cases in London, actually, at the Royal Courts of Justice and so forth. Then you've got all those other courts of appeal and so forth, but there was going to be a jury tied to that, and it's some of the council matters that you could have in there if you wanted, and have it higher. Which means that, but that's another option instead of petitioning Parliament. But I do agree that it did say that once the council has made a decision on something, right, there was only one avenue of option, which was to appeal to a committee of 3, which they're not offering us that now. They're saying there's no way of appeal, but I think there has to be a right to appeal something. But before you go into that council decision, and then you're meant to have the appeal that we've had supposedly taken away, before the council decide, you are meant to be able to opt to have a jury instead. But with the circuit judges, or the King's judges, are always meant to be higher than the local council, because the local council is all only equal to magistrates court and the county court anyway, and now they're just split into 3. So you're meant to opt to, instead of appeal it, well, you appeal it to a committee, you're meant to opt to go higher really in the first place at the outset. So we want this dealt with at the higher court, which you're meant to be able to have a jury. But you can do that as well if they don't follow the rules, or if they broke the rules, or if they didn't comply with the law. You can do that. But that judicial review, which apparently can't change the decision, you can have that instead before they make the decision, that higher thing, because they wouldn't have made one. Because how can that court even hear any matters to do with it anyway, even if they've done it wrong? This is the thing. But there's also the option of petitioning Parliament, which is a lot of people have done, like Stonehenge. But that's actually instead of having it. It's instead of having it decided by the local council. The Secretary of State says, effectively, in the modern law, he goes, okay, if you petition him for that, you're meant to get a local referendum. So, which is like having a jury. It's like having better than having a jury, really, because everyone gets to say, not just a few people. But that exists now. People aren't using it because Labour and the Tories don't want to give up power, and they're tricking us with these consultations, which are costing money. Those consultations are costing money, and this is the thing with Colchester Council, right? They're claiming that councillor is saying that, firstly, he didn't receive any letters. Well, I didn't write to him. Why would I write to him in an email when someone's actually collecting a petition that's meant to have a slot to be heard in the council and must be heard when submitted, right? And then the other thing is, why don't these councils cut their consultation funding? Because the consultation's pointless. It's got no judicial authority, so they're saying. The consultation doesn't carry any judicial weight. Really, what they're doing is they want to dip their toe in the water, see if the water's hot or cold. What they're doing is they're testing, to see what everyone's opinion is, right? If everyone goes flaming loony, they might think twice about putting the rest of their foot in the water. It's a bit hot. But, if it's not too hot and not too cold, even though it's a bit more hot than cold, then they might go, we don't have to, I don't have to abide by this, Geronimo, and jump in, In fact, some of the councillors might love jumping in when it's hot. They might like a good old hot tub. Everyone's against this planning application, but Geronimo, let's jump in the hot tub. Let's have some fun. Let's get some heat. They might like a nice warm hot tub. Like jump in a hot tub, and then when everyone else wants to jump in, then they're ringing the police security to get them out. Oh, this is a hot tub, We'll just sweat it off in here, and nobody wants this project, but by God damn, we're having it anyway, whether you like it or not. This is the thing. That consultation money, they're getting actually written evidence. That consultation is much more than a referendum, which carries judicial effect like a jury of actual numbers. The numbers dictate the outcome, for or against, right? They're actually getting statements, which you don't get in an election or in a referendum. They're getting statements from people, actually detailed written evidence, reasons why people don't like it or want it. So the fact that they don't have to abide by that, I was just getting an idea what people think. I think that they use that as a strategic thing to find out, who are our enemies? Who's opposed to all these people who are generally opposed? They know. The local council know we've got about 1,200 people who aren't keen on Labour's plans or whatever, but they're the people we've got to keep at bay. But we can just ignore them, because we never have to go on what they say, as long as we can get our sheep to elect us and get us into the chamber. But what's the point when you sign a selflessness policy and when you lift your hand up, you can't actually vote on behalf of a political party? It's illegal. The whole political party model is legal. So what upsets me is no one is exploring the Local Government Act and the Local Referendums and Elections Acts with a lawyer and trying to argue really technical law points on what is actually possible through those definitions of law for local referendums. You get all these really technical barristers and complicated lawyers who are arguing, whether someone, what did they mean when they insulted someone, and did they really mean to offend them? Very, very, being paid thousands and thousands of pounds to argue. Like this council have got this red button, this they call it a harassment button or abuse button or whatever. All that into that, Lawyers paid thousands to argue, did someone really mean to offend someone when they said this comment? Really extraordinarily technical. But they don't want to get that out with the Local Government Act for local referendums and things. Well, is it lawful within this act? Is there anything? Can you have a ward referendum through these rules? And can you collect 5% of the ward, which is, if it's 3,000, 300 people or whatever, or that's 10%, or even, 1,500 or whatever it is. Don't quote my maths or something like that, but it's achievable, and you know, it can. And if you only really need to collect, you know, X number of signatures, like, you know, 1,500 signatures, more people are going to be enthusiastic to want to try it. When it comes to like building a housing estate in one ward, you know, because that really, when you get that, and that's another argument for a lawyer or barrister. When you get that 5% of signatures, do they have to give you it? It says that it's got to be authorised by the Secretary of State, but when you get that 5%, it's like, you know, it's like you can. I'm sure that it's saying that, you know, you can have it. Once you get that, you've got it. But you've got to get it approved by the Secretary of State, because he's got to check it and count that you really got those signatures, and it's got to be officially, you know, put through. But I don't think that he can say and ahhing and say you can't have it. I'm quite sure that it's like, if in an election, if someone returns the maximum amount of signatures, they are elected, right? But it's still got to be authorised, you know, by the government, right? Because they've got to, you know, issue the statement and so forth. He can't say, oh, well, he's not elected. Although, if you read some of the ancient laws, they were doing that. If you read some of the petitions from Parliament, they were saying that certain people weren't elected, and they said that the person who comes second should be elected and so forth, kind of like election petition. But effectively, it's saying that if everything is done properly and correct and lawful, and you get those signatures, then they're meant to give you it, right? Because you've achieved what is asked for to get it. It's a function, right? You know, it means that if you put 15 bananas in a basket and then the tails skilt, the scales tilt, right? You know, that's the thing. You know, they've given you a target for what is required to have something, and if they, you know, that means that you can have it if you do that. So you definitely can petition Parliament, and I actually think that if this is the thing, what is it all based on? What is really happening here? Well, if that Local Government Act, if the petition for the referendum, that's been enacted in modern law, but what is it? What's it enacted on? What basis? Is it enacted on the right to petition the King or either Houses of Parliament? And if it is, and if that's, oh, what is this? Oh yeah, it's a provision in the Local Government Act where you can, you know, petition for a local referendum. Oh well, is that using the basis in the 1688 Bill of Rights that we could do anyway without that act, even without that act being enacted, that we could do anyway, and ask for the ministers to, you know, petition, or even petitions committee, you know, to get it debated, or assign it, or they even assign it to another committee in Parliament. Yes, it's actually the same, but they've created a new cool thing where actually what the Secretary of State does, very kindly, rather than the ministers who are doing very important business with Keir Starmer, you know, over whether they should make paper mile or whatever, they actually let the people have a vote on it in the whole ward or the whole town, and it only costs 600 and no more than 600 and odd pound per head. Oh, that's interesting. I'd like to know how much that it costs to run that consultation, because that's funny. You know, if it costs, you know, that consultation, how much they claiming that's costing, and they're putting down in the books for that consultation. You know, because that could you know, that could have funded a couple of polling stations. You know, particularly in a couple of wards for a few housing estates being built, you know, to poll 3,000 people. So it can't cost more than £900 or something each or whatever. It can't cost more than £900 per polling station per ward, or actually per ward. It says it can't cost more than £800 per ward. So I think every ward's only got one polling station now, although some wards might have more. But that's something. This whole Colchester Council oh, we can't afford to keep the toilets open, but we can afford to have a consultation because we really care about what people think and what they've got to say, even though we don't have to do what they say. So we claim, even though effectively it is a petition. And if the majority of people in the petition are for it, then the rest of the people who lost, who were against it, didn't win. So how can, if that's a consultation, you can't get more figures than that coming in. Well, we've got the maximum people who are interested who are going to apply anyway. So even if we did do a referendum, it's looking like these are the only amount of people who could be bothered having a say about it and turning up. But what we'll do is we'll do a method where that doesn't carry any judicial authority or weight. Given that, if it did, then it would be those people making the decision, not the councillors, not Labour and Tory. And if on this particular project, a lot of the people who never voted for Labour or Tory actually oppose it, then they're not going to get it, which is highly inconvenient for Labour or Tory, but strangely not inconvenient when the councillors are selfless and they're not meant to be able to have an opinion what their political parties want or think. So, how corrupt can you get? I mean, some of these councillors seem okay, reasonable people. I had to make a decision, I'm on the toilets, we've got so much money to spend, blah, blah, blah. Well, there are bigger fish to fry at the moment, like, where are our local referendums that we're not making use out of, yet you're going out of your way to, consult everyone. Have you thought of trying to lobby the government to make, public consultations lawfully enforceable over the council chamber? Hey, that would be a new act of law to put through, wouldn't it? In fact, it might even, if we were to find out that the council were managing to do these consultations on a budget, which was a lot cheaper than having a local referendum, and only the people who really, really were that bothered and really concerned about it were the ones who were writing in. We've found a new way to have a local referendum that's cheaper than having a local referendum, and people are giving statements. This is a amazing feat. It saves money. Why don't we just, if the Secretary of State approves it as well, then maybe it's got judicial authority, and then we won't need any polling stations because they can all just email the council in and give them their what for opinion. This is it. Unfortunately, I don't think that's Keir Starmer's idea of how you conquer a country and rule it as a monarch. Because then, if they were doing things like that on Paper Mile, then people might be voting against it, and then he's not the one who's making decisions. He's just a lever puller. He does what he's told. He's a tally man. Tally up the votes. Keir Starmer tallying up the jury's votes. And that's the thing. Starmer's going to be someone who goes by a jury opinion, supposedly, a random selection of the public. Regardless of what law he's presented and how much of a strong case that he's made, it's going to be the jury that decide. He doesn't seem to think that's the case anymore. He seems to think that him and Rachel Reeves should be making all the decisions in government. So, there's lots in that. Effectively, I think that the Local Government Act provides for petition to the Secretary of State, which is petition to Parliament, where you can have a decision on anything rather than the council making it, that is correct to models that went all the way back to the 1600s. I also think, instead of petitioning Parliament, you can actually go to the circuit courts instead of the local council and actually have a jury if you want, in a court of record with a jury, which is higher jurisdiction really than the council. And you might not understand that, but there's only really supposed to be 6 councillors, 6 permanent duats for the local area. And why, now that towns and cities grew and they divided them up into more wards, is why you've got lots of councillors now, 20, 30, 40, 50 councillors for each ward, because they created more positions. It's really like a grand jury kind of thing, like a big grand jury for a local area. And actually, it's still the lowest level of decision making. It's only same as a magistrate's court in like a criminal offence. The local council chamber, it's got that mace in it, but it's only like a magistrate's court. If you've took a pee in the park, exposing yourself in public, or you had a fray, or you smashed a window or something like that. It's actually not that different, and that's the reason all these councillors exist. All these many councillors exist because there are now many areas, because they built many houses, and they built many drive-throughs, and they built many things, so they need many councillors. And they're each like a juror, and this is where they've got the magistrates' court with another 3 justices in there. Oh, well, we'll have to... It's almost like you know what the magistrates' court is? What I've realised what the magistrates' court actually is now. Like when we said, if the council, right, make an order, a decision, in that act that I read, that 1600 model, or 1688 model, whatever, around that time, it said that you can appeal to a committee of 3 of them, right? Well, I mean, that could be appealing from all the councillors to vote on it, to just appealing to the cabinet to vote on it themselves, let alone just 3 of the random councillors. But what they've actually done, I think, now looking at it, I think that in my head now, I would see the local council from that very early model. Well, it's not that early, in the 1600s. Is I think that they've assigned a permanent committee to deal with crime, with three justices. But it doesn't really matter, does it? 3, whether it's Sam Sterling, the mayor, the recorder, and one of the aldermen, or 3 aldermen, or whatever. There are some records in like the National Archives in Kent. What it's saying, that it says that they decided that all jurors are equal to magistrates. That all jurors are justices. It says in the records of Kent. If you go into the records of Kent on National Archives and type in jurors, you will find a court in Kent was saying that there'd been a decision made or something that all of the jurats, the permanent jurors, were justices, which is what the 3. But you've got 3 of them who are you choose 3 of them who are going to be the cabinet on the council, that like the chairman or whatever, which is like the magistrates. But any of those councillors could be, but. It's a lot of them were sworn in as magistrates and so forth, but they ditched a lot of it, mainly because it was unnecessary. Like Sam Sterling, the mayor, is sitting a criminal case, but they're actually officially declared as magistrates and so forth. But what you'll find is that they started saying, "Oh, we've got too many, or it's unnecessary," and they started ditching them. But if there's too many of them and it's unnecessary, why don't they go back to just having the council hearing criminal cases and civil matters as well? It can't have been that unnecessary, or else, why is there so many councillors? Why don't they cut down on the councillors? So, really, what the magistrates' court actually is, I think, is it's like they've assigned a permanent committee, right, of 3 magistrates who really are kind of equal to councillors. Or justices of the peace, right? Or the permanent jurats, right? They've assigned them. It's a committee of 3. It's a committee of 3 for justice, for crime. because they don't deal that with that in the council chamber anymore because it's too busy with council business. And they've got I don't know what they do in the Crown Court. I'm not too sure if you have 3 magistrates in the Crown Court, so I haven't been in one, but I think they have a district judge. You see, the district judge can be in the magistrates' court by himself, or he can be in the county court. But I don't know if you have, if it's he deals with all of the. They've got other judges in there, but it's like they've got a committee in the county court to deal with tort cases and disputes between local citizens, like, you know, John owes Paul £20 or whatever, and they've got another committee in the magistrates' court, with 3 assigned to it, dealing with criminal crimes and criminal offences in the local area. And then you've still got your assizes, which is the Crown Court, which is the circuit judges going around sort of, and then taking over from. You don't need the quarter sessions because it's like permanent. It's not. They're not travelling around different areas anymore. You've got like they're permanent. You've got the Crown Courts there all the time, hearing cases every day. So you don't need the quarter sessions. So, but it's a higher jurisdiction. There's meant to be a role played by that level in some of the town centre orders, in some of the local council orders, as an alternative, because you get a jury there, but they've taken the jury out of it. But you've got a right to have a jury. You've got in Magna Carta, you've got a legal right to have a jury. This is the thing. So where are they in the High Court? This is the thing. It's not having one. It's so. I'm not talking about judicial review if the council have done something wrong. I'm talking about the actual decision on the matter they've got in front of them. Because remember, the assizes are the king's justices, right? And that's the thing, isn't it? You know, it's they're actually the king's justices, and it's funny them having that mace in the chamber there. Quite funny having it there, really. But they've even got, they have the crown symbol over the top of the you know, the magistrates' court has the crown symbol over the top of it, you know. So yeah, you're meant to this judicial review thing, or you know, you can only have a judicial review. I'm pretty sure you can object. You know, when you put at the stage where you put an objection into the council, because what they were doing was they were taking, like, writing everyone who's for it and everyone who's against it and so forth, right? At that stage where you can object, I think, because they've got to have a slot for petitions. So you can have, in that slot for petitions, before they've made the order, you can say, right, I'm petitioning the Secretary of State and we want a referendum. And they can't say, they can't approve it. So you're actually deferring the decision to Parliament. So you are petitioning Parliament. You're deferring the decision, you know, but you've got to have enough signatures to justify it, right? But I would have thought that, really, if you had a very, very strong case or reason for it, you know, like, the council are corrupt and they've all signed a selflessness policy which they're ignoring, you know, that would be a good reason. So at that point, so that petition slot, which they've got to have in the council, they've got to have, like, there's a certain time slot. I've read it. I've actually read that, where they've got to have petitions read out. You can petition Parliament in that slot. And at that point, but this is the thing, we didn't really think about this, and now people have, you know, they're saying, once the council's made a decision, that's it. But, you know, what about appeals? You know, it says that you can appeal to a committee of 3 actually in the council. But what I'm saying, before the council make a decision, and before this, actually, there is a legal right in law for an appeal, right? It's saying that. Why wouldn't you be able to have the county court decide? If it's put to a committee of 3, and if really the magistrates' court is kind of like a committee assigned for crime, and the county court's a committee for thing, that means that if you appeal it from, it means that you can have it means that you can have one appeal to the county court or to 3 of the councillors. I'm sure, not a judicial review, an actual appeal to the county court. Because it would be, wouldn't it? But it doesn't really matter whether it's 3 councillors or the cabinet of the council or what. But it said 3. But what I'm just putting the equivalent comparison, which means you can. Well, if the county court is the same level as the magistrates' court, which is the same level as the council, then there is an appeal to a body of 3, then it means that if the county court's operating like a committee of 3 from the council at the same level, which we know it is, you could appeal to the county court from the council on the decision, right? But that is instead of, if you do that, then apparently there's no appeal you can have unless they've broken the law or not applied something properly, which is where you get the Attorney General in. But that's for contempt. That's like effectively judicial reviews, like potential contempt. But we shouldn't be paying for that if it's the council that have done something wrong. Particularly if it's not a private applicant who you're opposing and you're not challenging them either, appealing them. If it's actually a council's project of their own, that they're doing their own project, because why should we have to pay for that? It's meant to be the Attorney General, you know. This is the thing. This is why the police have got a monopoly on crime, the CPS have got a monopoly on crime. What do you pay taxes for if something's corrupt and they've broken the law? So anyway, going back to that, try not to confuse it now, but going back to the main, so if the council are going to vote on something in planning, anything from a town centre redevelopment to a housing development or whatever, right? Really, if you're going to these sessions, like lots of people can't be bothered to go in, and really you're meant to turn up to, even if you've submitted something to advocate, it's only meant to be valid if you turn up and advocate as well, which a lot of people can't be bothered with them. But this is why this Colchester Council Watch is trying to get people interested in doing it, right? So, really, in that time slot, when you say, right, we're putting petitions down, right? You can put, that's when you can put the petition to Parliament. You can say, right, we want a referendum, right? Then, because you're petitioning Parliament, and that's why at that point the council can't decide. So you're appealing. You're not appealing the decision. They're saying, it's the right of the subjects to petition the king. Where you're deferring it to Parliament. And what Parliament have said in modern law, this is true. Effectively, what Parliament have created, they've actually created this in modern law now. This is the general opinion of modern politicians, or at least the ones, in recent history, apart from all this corruption or whatever, it's not all corrupt, but and there's a lot of things that they don't tell people about, don't want them to know about. Effectively, modern law has legislated that if a matter is petitioned to central government, right, then what they're doing is they're saying, well, we're actually not going to debate it in the chamber, or we're not going to. It's better. What they're saying is it's better that the local people have a referendum on it rather than us debate it in the chamber or assign a committee in Parliament to decide on it and make a judgment on it and then get it put through Parliament. To decide the matter instead of the council. They're actually which is quite a good thing, really. They're saying that's the opinion of modern law. The opinion of modern law is that if you petition the Parliament of England from a local council, which exists, right, in the Local Government Act and the elections, petitions and referendums and local government, this is a model they've made. They've made like a modelling law for it, right? Which I think that there's a lot of arguments that need to be had with decent barristers on your side in this, who can really help to get all this argued out into, absolutes, right? It really, they're saying that if you petition the Parliament and you've got adequate, petition signatures, then they're actually going to give you a local referendum, right? But the councils are doing consultation anyway, which is costing money, but they're not acting on it. So it really is a bit of a jip-off, a con. Also, I think in that petition slot, we're going to hear petitions now. So you can actually have it heard at the assizes, right? Which is the Crown Court, which is the High Court for civil matters. And supposedly, really, you should be able to have a jury as well, right? In the local area, picked at random, right? Now, you might say, well, yeah, but normally to go to High Court, you appeal, you go to county. Well, the thing is, what I'll say to that is this. Right, so when I got prosecuted by Leicester Police for dangerous driving, now that offence, right, can be, depending on how serious it is, it can be dealt with summarily or by an indictment. And if it's all summary offences, usually charges have to be brought within 6 months or whatever. Ironically, they did treat it summarily, but they took longer than 6 months, which I think is ridiculous because it's actually making them have longer than 6 months, and then they decide that they're not going to indict you, and then it's only treated summarily, but they've managed to get a summarily offence with the time length for a serious indictment offence. So it's really like a con, that, and I knew that at the time. But what happened is, I thought that the court decides how serious it is and whether or not you should go to the Crown Court or not. So what happened is, this is when I put a rights claim in, and I claimed basically parliamentary privileges or right to petition, and they actually said yeah, and I got a civil case to put that forward for my rights, which your rights are meant to be heard through overriding objectives anyway in the first hearing, and they should really be applied there and then. But that was probably the best thing that I've ever done, really. I should have won that. If I'd have known what I know now, I don't think that I would have lost it at this point. But anyway, so I'm in the court in Leicester, right? And there's the district judge there, Emma Fudge, right? And she's like, they said, okay, so they said that I can have the special rights claim, and they're going to hear it in that magistrates court, but in a civil hearing. So actually not in the county court. So you can actually have a civil hearing over a civil matter in the magistrates court, which proves, like I said, that with this local council business, and the local council don't deal with crime, or they don't deal with tort, well, it's interesting that you can actually have civil matters can sometimes be heard in the magistrates court with a district judge, because it's the same district judge who was in the county court. This is further evidence for this whole model like being sound, effectively. It just explains what actually it is, and it has evolved and changed, but you've got to still know what you're looking at, It's like, a rat's a bigger mouse, a rat is a bigger mouse, but it's still a rodent, That's the thing with these courts, it's like, the council's got bigger, and now there are 30 councillors or 50 councillors, but it's still meant to be a jury of 6 who are permanently sworn in for a long-term period, and the sheriff's there, and 3 of them are magistrates, and then you've got your recorder. That's what it is. It's just like a mouse turning into a rat. But anyway, so yeah, I'm in the magistrates court in Leicester, And it's this dangerous driving charge, which wasn't dangerous at all. I drove between two plastic cones at about 20 mile an hour in a straight line of traffic, which couldn't even, perfectly uniform line of traffic, which I just turned left between two cones and pulled left out of the line of traffic. And then the witnesses just made up false statements against me. But anyway, so I'm in the court, right? In the, sat at the bench or the chair or whatever, and then my solicitor's up at the front of the bar, and so the fudge goes to me, she goes, so then, would you like to have your case heard at the magistrate's court or at the Crown Court? This is for the trial part, they've agreed that I get this civil hearing to put my rights claim. This is what Extinction Rebellion should be doing, but they aren't putting rights claims in. They're just defending the charge and making a plea. So I goes, well, usually people are a little bit scared of having it at the Crown Court, because apparently they say the sentences are greater, but you get a jury and so forth. But it also, seeing all these Extinction Rebellion cases and so forth, now, I should have probably gone to the Crown Court, but I shouldn't have even been in there anyway, because of parliamentary privileges. But anyway, but this is that critical point is important. So I'm at a magistrate's court, right, which is a lower level court, and they're asking me, right, before a trial, and actually before I've claimed my rights, they're asking me, right, I'm not appealing. This is not an appeal, right? This is not like, oh, you've been convicted, so you appeal to the Crown Court and then you get your sentence suspended or annulled until the outcome of the Crown Court case, which is what you can do. No, this is before a trial, before a verdict, before a sentence, before the evidence is laid on the court and decided, right? She asked me, do you want it to be heard at the Crown Court or not? Oh, can you do that? Can you do that? There was a guy on Vobes, and he said, the judge, we were messing around in the court, and they were kind of roughing him up a bit, kept sending him down to the cells and then bringing him back up again. And then I think one of the judges said to him, what do you want, sir? What is it you have? What do you want? And he said, oh, I want a jury. And then apparently he goes, oh, you shall have one. But they didn't bring a jury into the magistrate's court. They actually sent him to the Crown Court. But I don't know whether it actually was an indictable offence. But I think that he was trying to use Magna Carta rights, and he said that I want a jury because I've got a right to have one. And apparently he was granted one, and they sent him to the Crown Court. But I don't think the offence was necessarily... I don't think he was there for an indictable offence. I think it was just a summary one. But I think they gave him a jury. So that's just now that point. That's really important because that point in time is pre-trial or pre-hearing, pre-verdict, and you're being offered a decision if you want to go to a higher court, right? Now, that model is there if we assume or use the general basis, which I'm trying to put out, that really the local divisional court, the 100, is what it is, right? Like what we're looking at on this screen. But there's only meant to be 6 councillors, but now there's that many houses multiplied in urban sprawl that they've got like loads of them. It's like a rat infestation, right? I think the magistrates' court is a committee for crime, right? Criminal law. It's a committee assigned to and given a commission by the government to hear criminal cases, right? And they were sworn in justices of the peace. But it's like having a committee of the council. We say, well, they're not actually councillors and they're not in a committee. True, but they've created 3 justices of the peace, right, who are going to be assigned to crime in that area. and giving them a commission for it, right? There were only 6 councillors. Now there are more. So they've created more councillors for each ward that they've created wards, right? It's just growth. It's growth, right? Really, the Magistrates Court it's like a committee for crime, but they're not actually the councillors, they're separate. And even now they've said that councillors can't serve in the Magistrates Court and so forth, due to impartiality and so forth. But it effectively is really. And that means that I think you can actually appeal the council to the county court, but you're not going to be able to, once that's it, you can't appeal it higher. But instead of having the avenue of council make a decision and there's one chance of appeal to a committee of 3, which could be now equivalent of a county court, right? Instead, when I was at the court and I said, do you want to have it here at the Crown Court? And I said, no, like the assizes, right? I think that model that I read in that book effectively is like, in that petition slot, you can say, oh, I'm petitioning Parliament instead, right? The Secretary of State, and we want a referendum. Or, why not the Petitions Committee still? Because it's... And really, right, I petitioned the Petitions Committee with that application number for that planning consent. That planning order for the town centre redevelopment, right? I petitioned House of Commons Petition Committee on the website, and I put resolution for planning order, 37984, whatever. And I said, we want to, appeal this order, right? They said, no, you can't appeal council orders. And I said, tosh. I said, rubbish, I can petition over anything, right? Actually, you can. Because it's saying in the Local Government Act that you can ask the Secretary of State. Well, the Secretary of State is the House of Commons, Parliament, right? He's a Transport Secretary. He's a member of the House of Commons. You petition members of the House of Commons through the Petitions Committee. So you can actually petition the House of Commons on that. You've got a legal right to petition the House of Commons Petitions Committee on that website before the council make a decision. Before, when they hear petitions in the local council, you say, right, I'm petitioning the Petitions Committee, and then you say, you fill it in and you do it. You get it up there live and you start collecting signatures. So you've actually got 6 months to collect the signatures. If you get 100,000, you can get it debated, or 10,000, you get a response. But I would have thought that because there is legislation in place that says that if you get 5% of your electorate, you can have a referendum. You can collect that on there. You should, if your electorate for your entire town is like 20,000 signatures, right? Then if you collect those 20,000 signatures on the House of Commons Petitions Committee website, which is like 20,000 signatures or whatever, which is like 10 more than a response, then the Secretary of State really, and the Petitions Committee, should grant you a local referendum. Because that's lawful. I still think that you can appeal to Parliament by petition, because it's just a right. It's just a right that we have. This is suggesting that you do it before the council have made a decision, but you can also, instead of Parliament, you can alternatively go to the High Court, which is the assizes, or the Crown Court level, which is your circuit judges, instead of the council. So you can choose. But the thing is, right, get this. What they were saying in that act is that, I'm trying not to make this too complicated, they were saying that if the council make a decision, and then you can have one appeal to a committee of 3, which will be like the county court, and then that's it. You can't appeal it then after that decision is final. Instead of that, you can choose to go to the assizes, right, and have a jury. But the thing is, from the High Court, doesn't say that you can appeal after if you don't agree with that outcome. You can appeal to Parliament after, not before. So it's kind of like there was a block between like your avenues of appeal going up through the courts, right? But now what I'm thinking is, it said that if the council make a decision and you don't agree with it, it can go to a committee of 3, but then that's it. There's no other appeal. But it doesn't say that if you don't ask it to go to a committee of 3, doesn't say that you can appeal to the assizes then, or even Parliament. And what I'm thinking of that is, if you go to a magistrate's court and get an order, right? Usually they say you've got to appeal to the Crown Court, right? But notice that in law, you can actually get it. It is possible to get them to look at it again. They can look at it again, or in section M80 or whatever it is, one of the sections, you can actually get them to look at evidence and set it aside if that's the right thing to do. You can actually set it aside, or they can look at it again. It can be looked at again. Sometimes if you're ill or poorly, and your probation officers get them to look at your case again and reevaluate, and you can get your sentence overturned. That's actually getting another judgment on your case or order. Now that really, they never hardly use that. They really don't like looking at matters again, magistrates court. They can do it, it's possible, but they hate doing it. They vehemently, they're trained and taught to resist it, and like brick wall it, but you can do it. That's really like when we just said the council in the old law can make a judgment, then you can have it referred to a committee of 3 to look at it again, but then after that, that's it. That's like having the magistrates court kind of looking at it again, right, in a way. But then it says, well, that's it, then there is no further appeal of pursuit. If you don't pursue that though, then you've not gone into that cul-de-sac of no further pursuit. It's not actually saying that you don't send it to a committee. You can have it go into the higher court. But what they are indicating it is that if you wanted it to go to the High Court or be dealt with it, then you should do it, first. Indicate that that's where you want it to be heard. If really the Court of Record, the King's Justices on the circuit, the Court of Record is meant to be like it's meant to be like it's like the Crown Court. They call it the Crown Court. It's the Crown Court. It's the Crown Court. You get a jury. It's a court of record. Everything is recorded. It's all above board. It's meant to be much better than the magistrates' court. My experience in magistrates' court is that they flaunt the rules. They cheat. They don't apply due process. It's terrible. It's not a proper court of record. Well, this is our current problem with the council. This is our whole things with the local councils. We think they're scoundrels. They don't, they're doing political party policies when they've got selfless policies. They're refusing to act on petitions, various other things. The council might look fancy with that mace in there, right? But actually, it's the Crown Court. And remember, the Crown Court's got a jury of people chosen at random. These councillors are elected full-time, but there's only traditionally supposed to be 6 of them. They're their full-time jury. But there's so many areas now to govern that they're multiplied. There's loads of them. But that's not that much significant when there's a grand jury. Now, you might think, well, look at that council chamber with all those people in it, all those elected councillors and all the effort to elect them, and they've just made a very important big decision on getting a town centre developed. Isn't that quite serious, It's the council, but it's actually not, because they actually are inferior to a Crown Court. That council chamber is inferior to a crown court with the king's judges, and a jury chosen at random, and obviously the High Court as well, and obviously Parliament. It actually looks a lot more spectacular than it is. It's just the local 100, and it just got a lot of weight on it because it's sprawled, it's grown, it's got all these urban areas, Dingle, Bringle, Shingle, Ningle, Brimthwaite, Bromthwaite, Bramthwaite, Southwaite, Shinkswaite, factory here, factory there, McDonald's, KFC, factory. They need all these councillors, right? Because there's lots of areas for them to meet with constituents and have a view. Go and get evidence, meet with people and so forth, which is a lot more regulated. If you think about the rules for jurors now, the rules for jurors is if you put those rules on these councillors, then there wouldn't be any of this colluding with departments and so forth. So I actually now think that I'm sure that you can, from that previous model, it's looking like you could ask for it to be heard by the circuit court instead of the 100, which is a court of record with a random jury, and they won't be biased either. Because that's the thing. If you think about it now, you voted for and elected your 6 councillors, the people that you wanted in the village to do it, or the town, trustworthy people. But with this political party, and they're all members of clubs now, they're member of the Labour Club or the Tory Club or whatever. But then they go in and sign a selflessness policy, which is insane, absolutely ridiculously insane. And then you've got all these, these contractors and Balfour Beatty and all these business interests and profitable companies involved in council departments, which is all wrong for projects and improving projects like all these BT projects and updating Wi-Fi's and all this stuff that a jury is not voting on. It can go, your random jury of whatever it is, 12, well I think it's 12 now, I kept saying 6, but your random jury with a court of record on a circuit with King's Justices, that is actually above this council chamber. And it looks flashy. It looks fancy and flashy with all the big cabinet there and everything and so many councillors there. But it actually is not of that high jurisdiction if you choose alternative judgment, which you can put a petition in to the Secretary of State, which is Parliament, which is the Petitions Committee of Parliament, which they've been rejecting them and not letting you do them. Now the only thing is that they're saying that you get your signatures from your constituents, but we know very well that in England every elector has the right to petition the king, right, or the king's governments, and we know that they do this. Do you work in the area? Do you live in the area? Do you use the facilities in the area? Do you go to school in the area? Well, I live in England, I go on holiday to Skegness every year, so yeah, or whatever it is that you do. This interest in the area, anytime anyone, if there's no interest in what's going on in the corner, no one looks, and then no one is bothered. If there's something going on in the corner and there's a crowd gathering and then people start going, oh, what's going on over there? Oh, we can't have any of that, right? You're generating interest. This is the thing. If you buy that property, you might buy property, right, in an area, you own it, right? But you don't live there and you definitely don't vote there. if you're from Scotland, right, and you buy field in Hereford, right, you own it, right, and the field is managed by that local government, but you're not an elector there, and you don't vote there, but you're going before that council to get that court to give you planning permission, right, because they're the ones who deal with matters of that area. But you're not from that area, or you might have a right, you got a right, privilege, or interest, but anyone's got a right, privilege, or interest in Herefordshire. They might like it. It's part of our country. You don't have to own land there. So if you work there, or if you use the public toilets there or go on holiday there, what happens if there's a guy in Scotland who's got evidence, right, that the guy who lives next to him, he overheard him having a conversation saying, I'm going to buy a field in Herefordshire. There's a farmer there who I don't like. He's an idiot, and I'm going to build a massive industrial unit next to his farm. That'll piss him off, right? And then that Scottish guy goes into the council at Herefordshire, puts his evidence on the table. I want to build this industrial unit, and then they make a case for it, and then the people who go object. Are you saying the only people who can object to that are the people who live in Herefordshire, when his neighbour in Scotland might have the evidence to say that, I have got evidence that he's doing that maliciously, just to piss his neighbour off, and therefore I'm putting in front of the council. I object. You got a right to object, and you also got a right to sign petitions. So what is your interest or privilege? Well, you've got evidence, But this is the thing. Anyone who lives in England is not like the United States of America. It is not separate states with different laws, right? This country is under King Charles III, right? That everyone's got a right to petition the King and His Majesty's government, any of it. There is absolutely no law in this country that prevents anyone from making a case to a local 100 or signing a petition. Now, you won't vote in an election, right, there, but this is the thing, right? If the Secretary of State grants an election in Hereford, right, all the people who live in the Hereford vote in a referendum. Sorry, if the Secretary of State grants a referendum in Herefordshire, only people who live in Herefordshire will vote in the referendum. But how do you get the referendum? You petition for it, right? But who's to say that you have to be from Hereford to petition central government to give a referendum to the local people there? You don't have to be from that county. And that's the thing, because at the end of the day, right, if you are buying a field in Herefordshire and you want to put a planning application in for permission to build, you're still not an elector in that area. So if people in Herefordshire sign a petition to the Secretary of State to get a referendum there, then the applicant's not going to vote in that referendum. But they can have one. The applicant is not going to vote in a referendum in Herefordshire if he's from Scotland and wants to build a housing estate in some fields. He won't vote. If all the people of Herefordshire get a petition for a referendum, the guy who's building the house won't vote in it, but he's the one who brought the case. And if people from all over the country want to petition the government for that referendum to be held, they can petition for it because they've got a legal right to. But they don't have a right to vote in a referendum because a referendum is different from a petition. You might have a right to petition for a referendum, but that doesn't mean that you have a right to vote in a referendum, because a referendum is a process by which particular people are asked in a certain area, right? But to obtain it, to say there's a need for it or a desire for it or a demand for it, you don't have to live in that area, because it was a guy from out of the area who caused the whole thing by buying some land, which he didn't need to live in the area to buy the land, and then he didn't need to live in the area to make a case for the council to build. So the applicant is unequal to the people who may support a petition. It's logic. So you can actually run a petition on HM government petition site for 6 months, and that should suspend the development of the town centre. If you're opposing development of a town centre, that should suspend it for 6 months while you're allowed to collect the signatures. And I don't think that the equal to 20% of an electorate signatures necessarily have to be from that area, although those are the people who will vote if you do get a referendum. But if you've got to match that area, it's like 20, usually something like 20,000 signatures, 5% for a whole area. But I'm sure you can get a ward. I'm sure you can get a ward referendum. It's a lot smaller, but I don't see why the Secretary of State can't grant it, and I don't see why the figure to achieve it doesn't have to be 5% of that ward, or even all of it. If you've got a ward, 3,000 is not that difficult. If you know that it's going to get you a referendum to stop a housing development, and really a lot of people aren't really too keen on it, and those people are likely to vote against it, why not? When you know something's achievable, you usually try really hard. And I think that when you get groups of women in local areas, like, 10, 20 women who are like really kind of keen on, blocking certain developments or trying to, they will try hard. And I think that if they realise and understand that if they even do their own little area, like, their own whole village, you get 6 or 7 people going around the whole village, and you can usually get people to sign it. I think that should entitle you to a ward referendum, which isn't allowed to cost the council more than £800. I mean, a lot of people, when they're facing these developers who are slapping down multiple housing developments, and they're putting millions into it, and they're planning the architects, and it seems like you're doomed, there's nothing you can do about it. It's actually not that much effort if there's 5 or 6 women and they go around and they get the signatures, 3,000 signatures even. They'll, like this Extinction Rebellion thing. All the things Extinction Rebellion are doing are a lot more difficult than that, and they have a lot more people. Extinction Rebellion should have been doing this. They would have succeeded so much more if they'd have pursued this and argued it out. But the council are just bluffing them and blagging them, and a lot of the barristers and lawyers and solicitors are kind of like maybe on the side of the corporate entities. You need this. It's this Local Government Act and the petitions and election rules model that needs to be advocated, that we are eligible to use it, and really it can intervene in local council decisions, and also the right to opt to go to the High Court instead of the council, the 100 Divisional Court. The local divisional court is only the lower court, even for local council matters, right? And that's the thing. I reckon if you check through all the history, I don't think I'm far from being wrong. There might be a few little ins and outs, but even all this modern legislation, the fact is, this is the kill switch, or not the kill switch, but the magic button, or the magic slot, or the thing is, in a council session, we got through all modern procedure and all modern rules, there is a allocated time for hearing petitions about the matter. But what petitions? Doesn't say, does it? Nothing says. Just says they've got to hear petitions. And I'm starting to think now that when they had the Tumultuous Petitioning Act 1661, and you had to get consent to petition Parliament if it was over 20 people, I'm starting to think that is the slot. And now when all the courts split off into the Magistrates' Court and the County Court and so forth, they don't have slots in those courts to hear petitions, do they? You know, but the whole case is, the case is a petition, but the council have got this petitions of numbers of signatures. I actually think now that I'm starting to think that maybe your councillors could have signed those off as well, like the local 3 councillors, because particularly when, or at least 3 of the when heads of councils were justices of the peace up till the 60s or 70s, or maybe a little bit after. So if they're justices of the peace, they could sign it off, the heads of the councils. You need 3 signatures. So I'm starting to think now thought about it, I actually starting to think that some of those petitions to Parliament would have been signed off by the council, that's massive. We don't have a lot of the records from Parliament because the House of Commons burned down in the 1839 or whatever, and all the House of Commons petitions, a lot of them were destroyed. But the old council records from the divisional area, I'm starting to think, might have records of petitions which were heard, but they might not have been heard in the council. The councillors might have just been approached individually to sign it, because you had to get the 3 signatures on it for consent. That's the thing. I don't know. This is what I need to find out. But that's I actually, what you see. This is the thing. You see what these councillors will say in Colchester. They'll go, "Oh, this is the Local Government Act, or this is this act, or this is that act, or this is this regulation, or this is this or that," right? In modern law. But they're not being creative when there's a little socket, right? Like a USB socket. Well, what can you plug into that? Well, it says USB. So what can you plug into a USB socket? If it doesn't say that you can't plug an earphone charger into it, or a smartphone, or a camera, could be whatever you want. It says USB, right? So in the council it says allocated time to hear petitions, but obviously for the matter that's being heard. But petitions for what? For the matters being heard. Well, you might want to have it heard at the assizes with a jury. You might want to have it heard with the king's judges at the higher level up, because you might say, "Oh, there's too many Tories in this council, or there's too many Labour voters in this council." They said they've got control, so but they've all signed a selflessness policy. So I want a jury chosen at random, which is higher. Why can't you petition for that? That's a petition. So he says you can petition over that matter. Well, I want it heard at the. It doesn't say. He says they have petitions over that matter, but for what? Well, I want the Secretary of State. I want a referendum, or I want it heard at the court. Because that's the thing with the petition. You've got the creativity, but it's got to be for the matter that's being heard. But the matter that's been heard, you're not. It's not an appeal, is it? It's an alternative. I think this is legit. I'm sure this is legit, and I do think also the council can actually look at it again. But on that matter of hearing it again and this assigning a committee, I think that you might be able to appeal to the local county court after they've decided. But what they were saying is that if you didn't want that option, that you'd just say beforehand. But I think the local council are not educated, not schooled, not told about it. I don't think it's been removed. What I think is you're in the same situation with the magistrates' court, trying to get them to hear something again. I think that when you try and get a magistrates' court to hear the matter again, they just blatantly won't do it, or act as if you can't have it, when in law you can have it, or have it set aside even. They just won't use it, or extremely rarely use it. And I really think that that's how we are with this council, with appeals. Even if you don't petition for Parliament or petition to the High Court with a jury, I actually think that they can actually assign it to a committee of three. Which, why is that not the county court? The lower county court, or even just put a committee there themselves, or even have the cabinet decide. I beg your pardon, appeal it to the cabinet of three or whatever. I just think they won't do it. They won't use it. Now, if they're going to say I'm wrong, and they can pull out an act of modern legislation which says, oh, there's nothing for that here, there's no process for that here, I'm actually willing to bet likely there is, but you've got to find it, just like there is in the magistrates' court, but they blatantly won't use it. Or, just because it doesn't say there is that, doesn't say that there isn't that. And this is the thing. Just because in modern law it doesn't mention something or say there is something, doesn't say that there isn't that option or it doesn't exist. So I think that is something that needs to be looked at. And that's why we need to get all these laws and all these previous council models and draw little spider diagrams of them and how they kind of like worked, avenues of appeal and processes, just like quite simple basic ones, saying, yeah, you could appeal to Parliament on this one, or you could appeal. The only bit I'm not certain about is it's certain matters within the council, like certain types of decision, like whether it was planning, change of use, or change of the rates and taxes, or trying to allocate money to certain things like the road and so forth. Some of them you could ask for jury, and others you didn't. Was it? But that's just what needs to be written down in a little diagram, and then how it changed. I think that you'll find that we absolutely and totally have a legal right to present a petition to Parliament in that petition slot allocated to hear petitions on the matter, and you've got a right to do that. And once you are petitioning Parliament officially, it is an appeal in law, and it does. It is meant to basically be the alternative judgment to the council. You've applied for alternative judgment. Now, there is a basis in law in the 2003 Courts Act and Justice of the Peace Act, I think 1997, where it says that this is something to do with the clerk's process, but it says that if any appeal to either houses of Parliament subjects any instrument to an annulment. Well, when local councils pass planning orders, they're making an order. You write out an order, like when you're convicted of a crime, they write out an order. And and they can also pass traffic regulation orders, which are a little bit like government instruments, but smaller and less authoritative. A traffic regulation order. It's like a little mini instrument. In those acts, it says that if you seek a resolution from either houses of Parliament, any instruments are subject to an annulment. But it says for criminal, civil and family matters, either or all. Well, the local council is actually still civil matters. I know that it's not tort, but it's civil matters. It's not a tort case, but it's civil. It's civil requests. I still think that you can appeal from the local council to Parliament and that their order would be subject to an annulment if you haven't asked them to go to a committee and re-decide it according to that other legislation I looked at. Which means that I actually did have a right to petition that petitions committee at Parliament, and that order should have been subject to an annulment while I pursued it for a resolution. Particularly like when you get 6 months to collect signatures from the petitions committee, because you're taking it to there is a right to take anything to Parliament. Although what Parliament are doing is deferring it to a local referendum. But I don't think it has to go to a local referendum. I still think that everyone in the country can collect signatures for it. But that's the thing. The only real argument in the local in the current modern legislation is if we can get a really good barrister to argue that you can have a ward referendum over a matter to do with a ward, and you can have a referendum at a polling station in a ward because it's a defined area. It's a defined electoral area of electors with a polling station. And why does it have to be all of the areas? That is the main thing that I want to get argued in the courts if I had enough money to get a barrister to do it. But then you wouldn't argue that in front of the council, would you? You argue it, well, unless the council agree with you. If you get a lawyer or a barrister to write a letter to the council and say, oh, we're entitled to a local ward referendum, and then you have one, they say, all right, we will, you've got no problem. But council legal services, all being Tories or Labour, will try and say, oh, no, you can't have that because they won't control the council. So that's when you have to take them to court. You're actually taking the council to court, but that's like they're in contempt. They're saying you're in contempt of the law because you're saying that this is tosh when it's not. And that is like kind of like sort of like judicial review equivalent, because it's challenging the council on process and procedure. Really, the Attorney General should do that, because the Attorney General is meant to be the person when the council aren't following the law themselves. You're not meant to have to pay for it if the council are breaking the law or not applying the law properly. It's meant to be, that's contempt. It's meant to be the Attorney General, right? Because why should we have to pay for it when the council are breaking the law? If an applicant, it is, then that's between, it's up to the council to sort the applicant out. They're meant to be the court. They're meant to be the judge. If you're appealing, in a lot of cases when an applicant brings it. So almost kind of like saying in civil court, right? If someone sues you just for, says they owe you 50 quid, and you go in front of the judge and you say, oh, can I have this heard with a jury, or can I have this heard at the High Court, please? Usually, you've got the right to appeal anyway if you're not happy with the decision. I think you can. I'm pretty sure you can do what I did. If I was in a criminal case and I was in Leicester and said, do you want this to be heard at the Crown Court or here? And I said, here, or I could have said Crown Court. I'm pretty sure if someone brings a tort case to you, even if you had a verdict and you're saying, right, I want to appeal this, I'm quite sure you might be able to say, I want a jury, or I want it to be at the High Court. You might be able to, I'm not sure. But that's kind of like what we're looking at with the council. Definitely can do it in criminal. But that was an indictable offence or not. But it's a serious matter. But that's the thing. Is the entire redevelopment of the town centre a serious matter? If it was equivalent to a crime, is it similar to murder or just like, smashing someone's window? Well, the redevelopment of the town centre is very, very serious, isn't it? So it would be like something that could be heard summarily or indictable or whatever. So you would have thought that, I don't want it heard by the council because it's quite serious, this entire town centre redevelopment. I want it to be heard with a jury, the assizes. So that's where I am with it now. And I think with these councillors, there's so many of them. But it makes the council look really bold and big with all these ornate things. But it's not. Because when you walk into like Stockport Magistrates Court, it's just like that bench there, right? So I actually believe, right, that you can bypass this council. You can bypass the council and you can get it deferred. In those older legislation as well, doesn't say you need a particular number of signatures. You only need, I think they go on the basis of two, like, when you say you can't, no one can be convicted except with the oath of two witnesses. It's kind of a little bit like that, you've got to get a certain number of people to consent to it and agree to it, and then, but that's kind of, now there's a lot of people, they go by percentage, I don't know if one person's petition could do it based on the strong body of evidence or on weight of numbers. But this is not like crystals and incense and tosh. I'm not blagging this or making it up. What I'm trying to do is, all I'm saying is, what is the true model, right? Draw a little spider diagram of the true model, right? 1600. What is the true model? 1650. What is the true model? 1700. What is the true model? And then what you do is you got to look at the model in clarification, and then look at the things they've changed and tweaked, or it's grown bigger, but you're still trying to find out if it's like, where's the head, where's the tail? It's like it's like looking at some kind of slithering creature. Has it still got two legs and two arms and a head? Is there still this because that's when your Magna Carta and your Bill of Rights come in. There's certain things that they've got to allow, that they've got to provide for. They can't not provide it. And that's when it comes in for like right to petition the Houses of Parliament about it, or right to a jury and so forth, although they're trying to deny that now to a lot of people, because they remove the reason why we've got some areas are suffering extreme urban overdevelopment is because it wasn't controlled by a random jury, and there were financial profits to be made. The Luddites tried to stop it. They wouldn't raise the minimum wage. The crime level went through the roof. They prosecuted them all. They expanded all the factories, more and more crime, low minimum wage. Then they create the police to deal with it. Then we don't have a monopoly on crime when we're not directing criminal charges. The police are directing criminal charges. Then there's all then everyone's off the face on drugs until the end of the 18th century, and then they create the Labour Party to get everyone to support Labour, go to work, forget all these Luddites smashing machines up, and forget all these civil juries that are trying to stop all these factories from being built. Let's get rid of them, and then let's get this Labour Party in, one for all and all for one, full pedal to the metal with all this factory business, and then the women come in saying, oh, well, we want the vote. If we're not going to be in the jury, I feel like there's one thing I need to research, which is if they had women in the juries in the 1800s. I think they did. I'm not certain. I'll check that up. But if they did, then the women actually didn't have too much of a bad deal if they could petition and if they were in juries, because they've got a lot of power on what gets done or not get done. But they wanted they got rid of the juries, and I think that in the civil courts, and I think that with the Labour Party being created, then women are arguing about wanting the vote to vote in who's going to serve in the council and in government, which that was a bit of a fight for them for that, and then we lost all that records of archives of petitioning, but then they said they're going to make all documents available after a lot of the important documents got destroyed. It's a miracle that all the session books... I think they're lying about that, because I think all the session books survived. Surely wouldn't all the session books have got burned if all the petitions from the House of Commons got burned? That's a question to find out. And the history of the bar, I want to see the history of the Bar of Parliament as well. But, I mean, this is where I am with it. So, what my current update... for what it's worth, I think it might be too late here. Although I tried to put a petition and they rejected it. I put it to judicial conduct. The council are demolishing the place. The petitions committee hasn't reopened yet. We're left in limbo. I think that you can go higher than the local council. Definitely. It's absolutely certain now that in that time slot for petitions, right? Which is a free creative process, a slot, as long as it's on the matter that's been heard in the council, right? What is the case? I think you can get it. You can ask for it for higher. You can go higher, and you can go either circuit judges with jury, or you can petition Parliament. And this is the thing with the Stonehenge Tunnel. This is why I said to you, petition Parliament. You've created a duality. You've created a legal case to the Parliament of England while you're pursuing a legal case in the High Court, right? And that is, it's like double jeopardy, but it's just like, that's wrong. It's like being on trial in a magistrate's court for nutting someone and being on trial for that exact same charge in the Crown Court at the same time. And then you being found guilty in the Crown Court for it and not guilty in the magistrate's court for it. That's ridiculous, right? And surely the higher order takes precedent anyway. And that's what Stonehenge Alliance have done in this highways place. And they're really not interested. I tried to explain it to them. The guy listened to me on the phone. He's like, we're going to go to the Supreme Court. We don't care. Or whatever. And I'm like, well, that petition is really why the government pulled it. And that's it. Well, so what about the planning orders in the local council? Well, they run out after 5 years. Yeah, but I want them overturning. Well, I'm like, well, the government have decided that they're not going to build a tunnel, so don't all the planning applications dissolve with it as well? It's a higher authority on that matter, the whole project as a whole, surely. And now we want to get them overturned at the Supreme Court. Well, you already got a petition to the House of Commons over it, which is already acted on. When the Secretary of State for Transport is really supposed to tell the council to quash those orders or, whatever, he wants to spend more money on judges and barristers and lawyers when the matter's been taken to the petition signatures are your strength of weight on it. From what I know from this model now, why are the council, right? The council have made planning orders, passed them, right? So that is like, what do you have to do? Appeal something that's already been made. When if you want to go to Parliament, you're supposed to do it before. If you take it to Parliament, you do it before. So then the council wouldn't have passed any of those orders, because if you take it to Parliament before, all of the matter goes to Parliament. All of it. Because you can have orders in council, like I said, raised to higher court anyway to be decided, not by the council. And this is the thing why Stonehenge Alliance, I don't think he wants to listen to me or be interested in it. It's not even a matter of what I'm saying. It's kind of like the fact that who wouldn't want to be interested in this? We're facing all these different council projects where we've got all these other things that are being done, and all these Colchester Council Watch groups and all these groups at the moment having major disputes with the council, they should, I want to learn what the models were for all the past councils. I want to learn them all. I want to know what the framework was and how it's changed and how it's meant to be. And I really am interested in what is actually going on here. And I want to get my head around what the council's doing. But it's too easy for them to just go, they can raise 5, 10, 20 grand so easily. People are just throwing at it. And it's like, we're a big group. We've got weight behind us. They're like, they can afford to just, kind of like go to a bar and have a piss up, we've got money. Well, get some barristers in, get them into the High Court, 130 grand, boom. They presented this really complicated 3-day case to stop Stonehenge Tunnel, but the High Court rejected it. We're academics, we're archaeologists, we're professionals, we're precise, we're professors. We must, how can we lose? But the thing is, what are you doing? You had 200,000 signatures, and you sent them to Parliament, and now you want another £135,000 for private profit for lawyers, right? When you've already made a case to the Parliament, right? And now you want another 50 grand to go to the Supreme Court for another case. It's almost kind of like, why not, right? Sue Sally, right, for 20 grand in the Magistrates Court, in the Crown Court, in the High Court, and send one to the House of Lords all at the same time, and see how many, orders you can get in your favour, and see how many you get against, and then which order takes precedence, the highest one. Well, Parliament withdrew the project, right? Really, the petition to Parliament, right, it's taking it out of the council chamber. And this is what I'm saying. You can stand in front of that council in the allotted time slot with a petition or your intention to petition, and you can remove jurisdiction from that council and move it to another authority, right? But they've done that with Parliament, and they've withdrawn it. But now they're wanting to go to the Supreme Court, because apparently different sections of this project were done at different times, and now there's some residue which hasn't been cleaned up, which they want to get rid of these orders. But Parliament, if Parliament have acted in any way at all, really, at that level, it has removed the authority from this council, And actually, like I said, you can appeal those orders anyway. There's definitely a process of appeal by a committee, and I think that Wiltshire Council should have an oversight committee to do something with those orders, appoint a committee to overturn them, which they should, really. If not Parliament, Secretary of State, send them directions to overturn them, which is how it's meant to be. Now, the only thing I can think of the problem with that is if you say, well, so, okay, if that petition slot is petitioning the Secretary of State, but what he does is he gives people a local referendum. He doesn't make a decision in Parliament. You can actually make a decision in Parliament. You can appoint committees in Parliament to deal with it. It even said that in the local council level, that they could appoint committees to hear an appeal. So Parliament, actually, there are other options besides giving people a local referendum. They could or can appoint a committee to deal with it and actually make a decision or order, because it's got a jurisdictive authority on it. I don't have enough time to read everything, but I've been focusing on privileges and rights for petition. But as I'm going along with it, I'm encountering all these skirting on these other subjects, which I'm also interested in but can't completely focus on, but are relevant and important to it. Like our local council just doing what the hell they want. All these big projects that they propose, which they act and behave like, it's inevitable, it's going to happen whether you like it or not. And there doesn't seem like there's anything anyone can do about it. When there is. In fact, you can remove it from the council. And there are lots of little processes and things you can do. And all these Facebook groups, small ones like Save Manchester Greenbelt and so forth, I'm trying to explain to them and they just don't want to listen, because if they can't see immediately when I'm trying to explain something to them that is relevant to their immediate planning order, then they just switch off or they delete it. And this is the thing, you've got a right to transact to people. Under the Public Meeting Act, you've got the right to transact information to a group of people on if it's relevant to their subject. And some of the admins, like this Sarah Orms, are just delete. She's like, she can't see how it's relevant, or if she can't see how it's relevant straight away, she don't want to entertain it. And that's illegal. That's Mark Zuckerberg and buttons. That is like, This Colchester Council said they were going to put all these buttons. Sarah Orme, she is not helping herself. She's a little bit like the Stonehenge Alliance. You get people who just want to, take charge and direct and control, and they're panicking, they're frantic, they're like headless chicken. They really want help, but they think if they can get more and more people and who are giving more and more people, then, she's asking people to fill consultations and do this, do that, sign this, sign that. I'm like, well, please listen to this. Let's do this. And because you're putting a position forward that you want them to listen to you, then they think that you're kind of like encroaching on their group and whatever. And if they don't immediately get it, it's like we're being obstructed from meetings like the Public Meeting Act, which is actually illegal. And this is all to do with Mark Zuckerberg creating these power buttons and so forth, which is really illegal, and it's really affected our ability to, permission to speak, sir, permission to post. All these public groups now are on, post approval, which in an emergency, if you want to put something up about insurance or legal or getting a barrister, or if you've got an act of law you want to put on there, it's obstructive, if not illegally obstructive. And, you might, they say, what about, behaviour in the group, controlling behaviour within the group? Well, this is the thing. You're not, no matter what you say in that group and no matter what you post, you're not blocking, if you're just a member and not admin, you're not blocking anyone else from saying what they want to say or posting what they want to post. So you're not actually obstructing the group from making any progress by being allowed to transact information which you think needs to be contributed, right? And that's why some admins, I think have lost the plot, really. And the culture's unfortunately slipped. And, that's effectively a big problem. But then again, you can be in groups and you can post stuff and people still might not get it or understand, and you still might get idiots. So it's very hard at the moment to get meeting the right people. I'm watching, if you want to, the people who are jumping in front of the camera and doing their own channel and, getting familiar with people and getting people to know them and then turning up at events like Resistance GB and they're meeting other YouTubers and interviewing other YouTubers and networking, like what Big Brother Watch do with this Unheard and Resistance GB and some of the Stop ULEZ groups. They've got figures who are the spokespeople, but their spokespeople don't always, they're busy. We're not organised. The problem with the council is they were very organised, and the Labour Party eventually, got very, very organised, and it's how they were politically successful. But the Labour Party wouldn't have come about, really. It was a pro-industrial worker class party to get all the workforce aligned for better work pay and better rights, but they would do it. It was kind of like, it did achieve what the Luddites kind of like were looking for, but let's not pretend. If Labour Party have ever done anything for minimum wage now, then you got to be joking. Particularly with inflation and cost of living now, which is a joke. They haven't levelled up the playing field at all from what the Luddites wanted to do, which is kind of like make the whole society more equal. It's got worse now, and I think if they kept the juries in the courts, they would have controlled a lot of the overdevelopment, and it would have been a lot more like Scotland. There were a lot of nice places in England that shouldn't have been overdeveloped, and a lot now that I get every second I speak, every day of the week is being massacred and raped, places and buildings, and I really think that we would have ended up being like Scotland. They've got Glasgow, they've got Edinburgh, they've got Livingston. An apartment block got banged up in Livingston, which ruined a beautiful place that I used to go to. I'm really disappointed about that, and I just saw a photograph of it about 12 months ago, and I'm like, I looked at the photograph. Oh, they massacred that beautiful little place where I used to stop and get out, and it was just a nice little place, and they massacred that. But Scotland's to not the extent of here. They've got cinemas, they've got McDonald's in Scotland, but as a landmass, with population and with older houses and villages and buildings, it's nowhere near overdeveloped. I mean, Sunak put a rocket station at Orkney, so I think if they'd have kept the civil juries and kept the council decisions open without cheating us, I think that with there still been technology, mobile phones, smartphones, all these vehicles, but just there would have still been a lot more countryside left, like in Scotland, and it wouldn't have been anywhere near as overdeveloped. If you want to say that's backwards, I don't think that Nicola Sturgeon thinks that as a woman she herself is backwards or medieval. She's quite probably confident that she is a modern woman. So I don't know what this kind of like Department of Innovation and Technology business is all about. So I don't think the Scottish police are any less equipped than the police in England. I severely doubt that the police Scotland, if they rock up with a bomb disposal team, are any less adequately equipped than English police. So that's just. I think that excuse is tosh. That it's backward or whatever. So there's a lot. We definitely we're being those public consultations are an insult. And then when the council are shutting down services like public toilets and so forth and saying they ain't got any money, yet they're running consultations that have no judicial power or authority, what's the point in them? According to what I'm figuring out through law, you can have a jury of 12 at assizes level, High Court level, decide on whether a town centre should be redeveloped anymore with a planning application. That's within English law and compatible with the law now. And it's a hell of a lot of money, true, for the council, but you get a random jury of people who might not all be... You see, this is the thing. Wakefield Council also now, right, are putting radio shows. They're sharing radio shows. And the radio show's called Regeneration Show. So it's like, it's not called Shall We or Shall We Not Regenerate. It's like, we're going to regenerate whether you like it or not. This, how should we do it? It's actually entertainment. A radio show is entertainment. And Wakefield Council are publishing that radio show on their website. wakefieldcouncil.gov.uk. They're publishing it on their social media. Now, in law, local authorities aren't allowed to influence electors in their support or opposition to projects or voting or projects. It clearly states also that they're not allowed to provide entertainment in exchange for votes or voting or anything that will affect votes or voting. And what happens if it did go to a jury and it's chosen by a jury and they've been watching Wakefield Council's propaganda of Regeneration Show? Jacob Rees-Mogg has been on GB News illegally because it's entertainment, and Ofcom have completely and totally they're wrong. They've been groomed and trained and set up wrong, because it's not a news programme that is banned and disallowed. It's actually entertainment. And Rees-Mogg was on there as a member of Parliament, and he was entertaining people. And that's illegal. And I don't think the Electoral Commission are going to do anything about it. I'm going to have to try and get the Forfeiture Committee to do something about it. And effectively, it's illegal. And what I'm finding now is all these councils on social media, particularly our council, they were doing all this blueprint promo and adverts as if like that to get people behind it and to influence them. Well, that's sometimes before they've even approved certain parts of it, because it's improved stage by stage. So they are influencing people against opposing it. And this is Wakefield Council are really deeply embroiled on this on their own website. They're sharing and putting radio shows which are pro the youth for redevelopment, and it's actually illegal that they're lobbying the public, and local council isn't allowed to lobby the public for or against their projects. And when you do take the council chamber session to petition signing in Parliament, what you find is that they're actually influencing that's referendum level. That if it does go to referendum, let's say you petition the Secretary of State from the local council and you get a local referendum, and then the local council, how are you going to vote in that referendum? The local council are knocking out fucking radio shows that are all like redevelopment youth show, which that's entertainment. So how Labour and the Tories are doing it now with all their collaborating partners, whether it's a rugby team or the bus company or the Balfour Beatty or Care or whatever, it is actually illegal and corrupt. It is illegal and corrupt. And everyone is in a donut trance, a Costa Coffee trance. And, you might say, well, what about some of these councils who have got decent councillors who are majority of independents and like quite agreeable and run a good council, like, places in Gloucestershire or Oxfordshire that have got, proud of their places and people are happy. Well, good for them. They're very, very lucky then, aren't they? That's not the case here. Our council it's a massacre. Never doesn't like itself. It's never liked itself. This is one of the reasons, why people from our area ended up at York getting hung. Some of those Luddites, although it started in Nottingham, not here, some of the Luddites from our area were on trial in York and they got hung. That's when Lord Denman was trying to stick up for rights, supposedly, although it was a Nottinghamshire movement, that. But understanding what happened, the removal of the civil juries, and then this, stopping the appeal from the council and on the control of the building, and the rest of it. And then the idea for the Labour Party to do something for the workers, but really it was getting the workers to all carry on working, but in an orderly fashion. And okay, we'll try and negotiate some better deals. It was far from getting the juries in on the job and stopping a lot of the overbuilding of it and the spoiling of the areas, and the outcome of some of the civil cases against, factory owners and so forth. So we have been hijacked by corporate entities in council. And I think that Extinction Rebellion want these citizens' assemblies. But we didn't. The jury is a random assembly of citizens. Right? And you could have that back then. We've actually had our assemblies of citizens taken from us. That's what's happened. And the Labour Party was formed to try get them all to all aligned to align to the favour of the companies, but just arguing for a better deal. And then the women come back in. They want a right to vote, who's going to be in the government and parliament. So it has been a process, really. But I'm really onto this petitioning the government. I'm really big on petitioning. I think that there's a place for it in the council, just for putting a petition to the council to try and persuade them by way of signatures in the initial decision, which might not necessarily have any evidence, just numbers of signatures. Doesn't seem to have swayed that councillor with the public toilets in Colchester. You can petition Parliament, and I'm quite certain now, I'm absolutely convinced from reading earlier local council acts and formations that you do it in that time allotment for presenting it. That's when you declare it. Right, I'm petitioning Parliament. So, tough. You see, in 1661, you had to have permission from 3 justices, right? If it was under 20 people, you could do it without consent. But that means that you would have been able to ask for the High Court or a Parliament decision. And if there's over 20 people and a lot of people, there's a hell of a lot of people behind it. Well, what consent do you get with over 20 people through the 1661 Tumultuous Act to petition Parliament about a local council development if you need 3 justices to sign it? Oh, I'm in the local council. There's 5 minutes to hear petitions. Oh, I need 3 justices to agree consent to it to petition Parliament. Oh, what coincidence! One absolute coincidence. It says here you can petition from a local council matter to Parliament. The 3 cabinet councillors are justices of the peace before 1980. What coincidence! This is a hot spot. Fuck me. Sweet gee. Where am I? What am I doing? Oh, there's a council. That's funny. I've got a petition to Parliament here. I need 3 justices to sign it, and there are 3 in front of me with another 6 councillors. And here's a petition to Parliament which needs approving by them to appeal to divert decision from the council to Parliament. Where's the fucking DeLorean? There's 2 streams of fire and fucking lines on fire there. It's like, fuck me, where's the TARDIS? It's like the fucking Terminator with a, knelt down, all rise. It's like the fucking Arnold Schwarzenegger, the Terminator, I'll be back. This is it. Oh, there's a 1661 Tumultuous Petitioning Act. There's 30 women here who don't want the toilets demolished in Colchester. We need the consent of 3 justices. Oh, will those 3 cabinet council members do? Seeing though that they are or were justices of the peace, and this is the perfect time to declare that we're deciding that we're going to defer judgment to the Parliament of England and collect a lot more than 20 signatures on it. We're going to try 100,000 or whatever. I couldn't be in the better place at the right time. So it's just all, ta-da! It's like on the Blues Brothers when the light comes through the window. Do you see the light? This is it. I mean, we've repealed that act now. Oh, well, if you repeal that act, then I don't need 20 signatures and I don't need consent for the councillors then. That means that we can do the petition to Parliament and we don't actually need consent from the councillors or the cabinet in the council, do we? And we don't need 20 people. That means that it could be 15 or maybe even 14 or 12 or 2. In fact, I'll build I'm in the council. Here's my tablet or laptop. I'll just turn it round. Here we go. Petitions Committee, Parliament. We defer Town Centre Development Planning Application 6524 for a referendum in Colchester. Press send. Oh, you need to collect 5 signatures before your petition is published. Oh, what coincidence! Does any one of these councillors want to sign it? there's a couple of people in this council room here. Do you just hold that there? Do you fancy signing that now? There you go, 5 signatures. Oh, I've just got an email. We're checking your petition. Message from the Queen. Message from the Petitions Committee in the Parliament of England assembled in SW 015 Central London. Email from the Petitions Committee in Parliament. We're checking your petition before it's published, and you can proceed to collect your 100,000 signatures. Well, there it is. It's official. It's a posterius. Look, there you go, Councillor King. You're posterius. You can You'll have to, I'm sorry, but you won't be making this decision anymore in this council unless we fail to collect the 100,000 signatures in, 6 months. But we only need, what's the 5% electorate of Colchester? Oh, 20,000? Well, at 10,000, we'll get a response from the government. And then at 20,000, I'll be writing to the Secretary of State saying, oh, we've got enough signatures now. We don't need 100,000, Who would have known? Who would have thought? Who could have conceived that actually is the procedure?